How do you make a house avoid the probate process when you're trying to pass it down to your spouse and then your kids? You have a couple different steps that you would need to take without a revocable trust. So if you're considering you and your spouse, you can set up joint tenants or rights of survivorship. And then when the first spouse passes away, that their part of the ownership of that house will pass directly down to the second spouse, who is the surviving spouse, and then they would have 100% ownership over that property. The problem is going to be that when that second spouse passes away, it will not avoid probate to go down to the children. And so when the first spouse passes away and the second spouse has 100% ownership, then the second spouse can go in and update the title of that property to be transfer on death deed, and then name the children as the designated beneficiary. That way, that house will avoid the probate process and go directly down to the children. So you have a multi-step process there to make a house avoid probate when you're passing it to a surviving spouse and then down to the children. The risk here is that the second spouse may forget to set up the transfer on death deed, they may be incapacitated, or whatever reason, it may not avoid the probate process. So you're leaving that up to chance. If you put the house inside of a revocable trust, you and your spouse are co-trustees. When the first one passes away, the second one can still benefit from that property and have control over it. And then when the second spouse passes away, that house will avoid the probate process again, and you can distribute it out to the children. That way you avoid the probate process in 2 steps. You don't have all these multi-step processes to make it avoid the probate process. You just do one simple step, and it completes the whole route of that house avoiding the probate process. If you want to learn more about this, we have a free webinar. Click the link down below and schedule a free spot.